Alan Parsons Project, the band that I know best from 80s hits that sounded like 70s hits, like the sublime Don't Answer Me. And you may know, even though you don't think you know, the song Serious, which is best known as an NBA walk-up song. Now, there are only two members of the group, Alan Parsons himself and Eric Wolfson. And over the years, they recruited hundreds of other musicians to play on their albums on a work-for-hire basis. But the two of them only did one series of concerts as the Alan Parsons Project. And years after that, a promoter approached Alan Parsons about doing a series of concerts. And it's not very clear from the court decision what became of that, but the contractual relationship deteriorated, and later the promoter tried to solicit other musicians who had played on those records to do concerts. And when he did that, he referred to them, and the wording is important, so I'm going to put it right here, as the original musicians of the Alan Parsons Project, and sought to promote those concerts. Alan Parsons wasn't very happy about it, so he sued for trademark infringement. By this time, he was the only surviving member of the two, and he owned registered trademarks in the Alan Parsons Live Project and Alan Parsons, and claimed what's called common law trademark rights in the Alan Parsons Project. He sued for trademark infringement, which requires a likelihood of confusion as to sponsorship in this case. And this is where the promoter claimed what's called nominative fair use as a defense. That's where you're using that trademark in such a way that doesn't suggest sponsorship, but you needed to identify your services. For instance, arguably, I am using the trademark in this video nominatively. Well, to get the benefit of that, there are three things you need to show. Number one, your services are not readily identifiable without using the trademark. Number two, you only use so much of it as necessary to identify it. And number three, you do not use it in any way that suggests sponsorship by the trademark holder. And it's on this third factor where the promoter lost. I think he ought to have lost on the second factor as well, but it was enough for him to lose on the third factor. The promoter claimed this isn't misleading because I don't say that they're original members. I said that they were the original musicians, and the court did not think much of that distinction. Parsons won. He got an injunction, which means he got a court order prohibiting the promoter from using the Alan Parsons Project name in connection with the concerts, and also a monetary damages award of close to $5 million. So let that be a lesson to you if you're doing any type of tribute concert, to be really careful about what you call it and how you phrase it, and consult with an experienced trademark lawyer, ideally, about how to do that. I'm serious. My name is Mark Jaffe, Five Bridges Law, representing creatives in California and New York.